everyone, and welcome back to another episode of Future Contracts. Today, I have Frances Gordon with me, and we're going to be talking about something that is really close to my heart, and that is plain language in contracts. Frances, it's great to have you here today with us.
Thank you so much for inviting me.
Of course. Frances, do you want to tell us a little bit about yourself?
Well, I'll tell you what I'm doing right now. I'm director of a company called Narratology, and we consult and train mostly to financial and legal companies about making their communication clear and accessible. Recently, we have redone all our consulting and training to address the revolution, which is generative AI, which I believe really can help us scale our efforts in clear and accessible communication. So I'm very busy with that. And I'm also here today really because I'm UK ambassador for a great organization called the Plain Language Association International. So I'm very proud to be part of the plain language community, and I've been so for many years. So it's wonderful to be here.
Excellent, thank you. And you and I met years ago for the first time, didn't we? When I first started up TLB, which was the legal ops consultancy that I had prior to my role at Law Insider. And we both shared a passion for making contracts simpler and more accessible and readable and just plainer. So Frances, how did you get into this? How did you find your way into the world of financial contracts and plain language?
Well, it's interesting. I started very far away from it. So my first job was as an adult education materials writer in rural South Africa. So for the first 2 years of my career, I was traveling from little village to little village, writing materials to teach adults how to start a candle making business, or how to sell food from their food garden, or how to make money out of childcare. And I couldn't really pay my rent that way. So I was looking for a job, and it was so long ago, we actually looked for a job in a newspaper. I think many of the viewers won't remember or won't know this, but we actually looked, we paged through newspapers for jobs, and I saw an advert and it said, write in plain language. And I never heard of the term before. But I kind of thought, well, I think I've been doing that. I've been writing for people with low literacy. I think I can do that. So in the sort of confidence of youth, I applied, and it felt almost the next week, obviously it wasn't that, but it was just after one or two interviews, I found myself in London working for seemed to me, very fancy consultancy. And we focused on clear communications for some of the biggest businesses in the UK at the time. And I was working on bank statements and telecoms bills and writing policies and, meeting in the city of London. It was very far of what I was used to. And I always think back, and I think it probably took around 5 years for me to really understand why I was hired. I'd become very interested in the field then was called information design. And there were great organizations and great meetups that we did to learn more about information design. I was fascinated by it because it put down on paper and in theory what I had been kind of doing intuitively in my previous job. But I still didn't really understand why I was hired. I was kind of, why am I here? I didn't have a degree in business or in law. I had a degree in linguistics, so very theoretical knowledge of language. And I realized when I started hiring my own team that why I was hired and what was most important about this whole field of plain language was being able to really think deeply about the people you're writing for and really understand what they want to read and really understand what they need to read and be able to empathize to this very deep degree. And I always say that's my superpower. It's about asking stupid questions no one else will ask. And it's about really thinking about the people I write for. In a way, all the theory that one learns on top of it about content and about technology, to me, those are just, basic new skills on that scaffolding, which is understanding reader needs. And I really liked information design. Where then I started really focusing on financial and legal, I think, was after the dot-com crash and the financial crash, where I started realizing that the real need for the skill was in financial and legal communication to help people really understand the terms that they're bound by. So I think it took those kinds of experiences to make me focus where I am now on content for financial, legal, and still pushing the plain language bandwagon wherever I can.
As you should. What a wonderful story. Thank you for that. So you've been in the field for probably longer than anyone who has a familiarity with the term plain language. What kinds of communication problems do you keep seeing in regulated content, regardless of geography? Because you've got this experience across borders. What are the most common issues that you see?
Sure. Well, I first want to say that there are many people who've been in plain language even longer than me, and I encourage people, if they're interested, to look at the Plain website. And there's a wonderful conference coming up, and so I just wanted to want to take that honor of being in it the longest. But in terms of the common problems across borders, across industries, I think that we often think we write plainly because we understand it. So if you are a lawyer and you've been to law school, you're going to pick up a contract and you're going to go, but this is fairly obvious. It's fairly easy. I can't write for people who can't read or don't want to read. I think I'm doing the best I possibly can. And you often end there. What you don't do, because in our jobs we aren't given the opportunity to do, is to understand and really learn about the readers. So I would say the number one problem is that all teams don't understand what readers really want. And I think, dare I say, legal teams are sometimes the most guilty of this. I'll tell you another anecdote that struck me very deeply. It was a couple of years ago, and I was working in one of the city law firms, a top floor, beautiful view of London. I was sitting with a bunch of lawyers, and we were actually redoing a set of terms and conditions to do with the GDPR, those kind of changes. And these meetings are my favorite things to do when I get to sit with a whole lot of lawyers and business people, and we reshape these contracts. And you can imagine the cost of these meetings. And it's a big cost. And we're working through it. And then we have a lunch break. And I remember one of the partners said to me, well, Frances, you must understand that nobody's going to read this thing. Nobody's going to read it because even I, he said, won't read it. And I think that's the mistake people make, is we put our own assumptions on it. And my answer to him and my answer to all these businesses is, as a lawyer or as a manager, you're actually not the people we're writing for. We're writing for people out there who really need to understand how this financial product works, who need to understand the terms and conditions that bind them. We're not writing for the lawyer. We're not writing for you. Yeah. And out of that very kind of fundamental gap between the writer and the reader comes all the problems. Because once we don't understand that, then everything is going to be a battle, because the people who own the documents don't really understand what they need to do to make it right. I never think there's bad intent, and I've been in this for many, many years, and I rarely have, maybe once or twice, seen bad intent and people who want to confuse or want to be ambiguous. It's not a bad intention, rarely. It's just complete misunderstanding or not enough understanding of what the reader wants. And I would say that's common everywhere I have worked.
Yeah. And also, I think the way that lawyers are trained, we're trained for risk aversion and to try to think about the worst case scenario, which is this is going to get litigated. So the way that lawyers draft is often for the benefit of a judge in the event of a dispute that gets escalated to that level. Whereas actually the bit that I think we're skipping is, what's the utility of this document beyond it just being a protective mechanism? How are we going to get people to read this? Because by trying to get people to read this, you are firstly serving the business that you're working for, if you're writing in a business context, because you're conveying the messages and the brand values of that business to the customer and building that loyalty and transparency with the end user. You're also mitigating risk, because if the other side understands what it is that you've written, then it's likelier that they won't breach their agreement, or that they'll follow the process that you're asking them to. So because there is a misconception that by using plain language, you're in fact increasing risk because you're not writing in watertight legalese. What's your view of that?
I think you're absolutely spot on. That there's this phrase of the tried and tested, the precedent, and I think perhaps in the past that might have been valid, but now we are in an era where the FCA, the Financial Conduct Authority, for example, in the UK, is very much looking at whether people actually understand, rather than whether your clause is the same one that's been used for the past 30 years, right? We're looking at whether people actually understand, and they've become very interested in those outcomes, and looking at outcomes. Do vulnerable people really understand? What are the outcomes of that piece of communication? So I think even from a risk point of view, that is no longer valid in many contexts. In terms of the business point of view, I always find it strange, and I will never stop being surprised by this, that a lot of companies spend so much time and money on their brand and on their advertising and on their social media, and all of this are wonderful things. And I would never say don't you shouldn't spend money on that, but wonderful things. But and you get these wonderful emails. I'm sure we got them, and you can see someone's really researched these direct mails and looked at them, and you can see they are perfect. They get across the point. And then you get the email about, we've updated our terms and conditions. And there's such a mismatch, it's almost laughable, isn't it? Between something that's so perfect, it's clearly been tuned, so much time and effort has been spent on it, and then we've updated our terms and conditions. And I think that the market has changed. I think that especially younger people that I speak to are pretty savvy, and they know that it's those terms and conditions that are going to matter, not that big advertising promise out there. It's those terms and conditions that matter. So to really relegate these these legal and financial communications to this sort of small print approach, I think from a business point of view is also a bit misguided. And I do think that when companies do communicate clearly and honestly, they are rewarded in terms of customer trust, which
Yes,
has been shown. So I think a lot of these notions, I absolutely agree with you. There's a lot of kind of misguided thinking about the amazing role that actually legal communications can actually play in your brand.
yeah, totally. Francis, you're the UK ambassador for Plain and a strong advocate for ISO 24495. For those who haven't come across it yet, what exactly is this standard, and why is it just such a big deal for legal and financial
Yeah,
teams?
it's a really big deal for people like me, but I think also for large organizations, and perhaps most importantly for our consumers out there. So for many years, we had plain language, this word plain language, some people called it plain English, and every consultant or company would have their own kind of interpretation of what that meant. And some consultancies would just say, oh, it's just about readability guidelines, that grade 8 or grade 10 or what that kind of stuff. And some of them had very sophisticated measures of what this plain English or plain language was. The problem was that because we didn't have something consistent, it was very hard to measure outcomes across organizations. And I think it was very hard for regulators to really measure things or agree with what things were. The ISO standard, this process of this ISO standard started, I think, 2014, 2015. So it's been a 10-year process. The ISO procedure is extremely rigorous. So this one involved consultations across 25 countries, 19 languages, and a lot of consultation and rigor. So now we have a standard that is not only consistent in the UK across, but it's actually consistent across 25 countries. So if you are doing cross-border business, or if you just want something to rely on and are tired of arguments about whether, the active or the passive voice is right or whatever it is, it's something that we can all lean on and say, this is the standard. We've got something to lean on. The other reason, so it's exciting just because it's a standard, and we haven't had a standard before. The second reason it's exciting is that it's a very good standard. And why it's good is it doesn't just say, your sentences must be, X sentences long, and you must use this word rather than that. That's actually not the focus of the standard. The standard is very much about a principle and a meta process for addressing plain language. And it spends a lot of time talking about how you should try and understand your readers, how you should try and understand your context, how you need to get feedback from users while you're developing the document. So all of these issues give us a very solid foundation for what plain language is, and it says all the right things. So I think people who adopt the standard can have some certainty that they're following best practice, they're doing the right thing in this field. So I think it is a big deal. Very excited about it.
That is amazing. I wasn't aware of that. I didn't understand how rigorous it was and how prescriptive, which is great because I think ISO standards can feel abstract to people who work with words.
Yes.
So what does it actually look like to apply plain language to a real contract? Can you give us an example of what might change before and after the standards applied?
Yeah, it's a really good question. And I think if companies apply the standard and apply plain language properly, the outcome is the work is not going to be just rewriting. It's not going to be, I'm going to outsource this to the world's best plain language writer, and they're going to give me 3 drafts, and I'm going to feed back on those 3 drafts, and it'll be finished. And my sentences will be shorter, and I'll have lots of active voice, and I've explained all my jargon. It's going to be great. The problem with that approach, and I've done that approach many times because it's sometimes been the only option, but I can say the problem with that approach is within a few years, the contract goes back to what it was before. And it's great because then plain language consultants will get it again and do it again. And it'll always start reverting. To apply plain language properly, it starts with research. So it starts with looking at the readers and doing a reasonable amount. And I'm saying reasonable, it's not excessive, but doing a reasonable amount of research into the baseline knowledge of those readers. Do the readers understand, I don't know, what arbitration means before they're starting? Do they understand what risks they actually face with this contract? Once you have this knowledge, then you know what to say. So the standard actually says 4 main things. It says 4 main principles. Communication must be relevant, so you must tell people what they need to know. So for instance, if they don't know what the risks are, you're going to have to tell them what their risks are. It's not good enough to say, well, I assumed that the readers would know what arbitration is. If you need to identify what readers do and don't know. So it's got to be relevant. The second thing, it's got to be findable. So that means you can't have the classic important stuff, in 8-point font at the bottom of the contract. And these emails that go, we've updated your terms and conditions, and just give you the new version and don't tell you what's changed. So it's not really findable what you're looking at. That's going to be a problem. The third principle is you're going to look at is it actually understandable? So with findable, you're going to actually work out how people can best find that information. For understandable, that is the rewriting part. You're going to actually rewrite it. You're going to look at any legalese, get rid of the legalese. You're going to decide if you need the legalisms to the terms of art. And if you need a term of art and you found out your readers won't understand it, you're going to explain that term of art to them. So you're going to write it, and then you're going to, in the process of doing all of that, you're going to measure its effectiveness. So you're going to monitor and evaluate the outcomes of that. So you can see when you apply plain language properly to an organization, it's not going to be just sausage in, sausage out. It's not going to be a factory approach. it's going to start with real understanding of the readers and a different approach to actually writing. Funny enough, an approach far more aligned with user experience writing or with content strategy. Everything is going to be included in one kind of process. So doing plain language properly is going to, it does, is often a very new approach, especially for legal documents.
I recorded a podcast with Astrid Kohlmeier. I don't know if you're, you
Yes.
must, yes, yeah. She's done so much work on legal design and has been part of the very small group of people that have even coined the term legal design. And this is information design, and it falls within the realms of legal design, which then falls within the realms of design thinking. And I think it's just taking that empathetic approach to your deliverables. You know, if you're creating a contract, you need to be thinking about the person who's going to use it, and just that fundamental shift, the mindset shift, has a knock-on impact on the whole approach, as you're saying. I think the other thing that this will do, and I'd love to hear your thoughts on this, is it will have to align people from different functions within the organization in order to maintain this standard. So you mentioned UX and content writers, and is that something that you see happening because of ISO?
It's I'm not sure if it's because of the ISO. In fact, I think it's just the general culture shift we're seeing in companies. I'm seeing a lot of silos break down in general in organizations now, which is a very good thing that this is happening. And I think that this particular standard it just sort of fits into this whole entire process of everything sort of coming together and being dealt with properly. I think that if you look at legal design, if you look at plain language, if you look at, and it's all part of the same thing and design thinking, where we co-create with users. We don't think of users as people out there that we don't actually speak to. We bring them into the room, so to speak, and we kind of monitor our document creation process or design process as we going. So to me, it's all part of kind of a wider culture shift that's happening with organizations, because a lot of plain language is particularly, I think it's particularly relevant to legal, just because it's been so hard to reach the legal documents. They've always kind of been excluded because the legal team has owned them, and they've kind of been different. And if you're a content person in a large organization, you often don't even think of yourself working on those documents. You kind of think of yourself doing product content and marketing content, but you don't really think of yourself doing legal content. And that's the shift that I personally have always wanted to change, because I've always thought it's absolutely ridiculous, really. Why should I, as a content person, not be able to bring that legal content into the stable? And I think for me, I'm very much less interested in who owns a document. I find that quite an interesting way of approaching documentation, actually, because I think we all own different parts of content. I think there's a very old-fashioned notion of people own certain things. We all own parts of things, and we all own parts of risk when we're looking at risk. So I think that this standard it almost forces the legal content to be part of a wider content strategy. And that's very exciting to me. I'm for many years, I've been one of the few content people that has been fascinated by legal content. And I remember when a few years ago, I led a content team at one of the big banks. And I went in and found the team was extremely negative about the regulation. So they were like, "Oh, this prescribed wording, it's terrible, but we can't do anything about it, and it's just awful." And I made them read the regulation. They couldn't believe it. Say, well, have you actually even read what you're actually trying to do? Have you tried to understand it? And they went, "This regulation, it's so long, I can't read it." And I went, "I think you can read it. I think you can do it." And they all read the regulation. They were like, "Actually, that makes sense." That's okay. It was lots of bits that they didn't read and, didn't study it, but they got the gist, and then they could respect it. then they could, I understand now why we have this prescribed wording. I can work around it because this is quite interesting to me. And we ended up doing a big research project on it and a UX research project on it. But I think that engagement, it's not only the lawyers that are the problem. Sometimes it's the content team too. And we have to make that content team interested in the legal, and we have to make legal people interested in content or design, or both, hopefully. So, and I think the standard really almost forces that to happen, and that's really cool to me.
It's very cool because, and I think that a lot of this comes down to fear. A content writer with no legal background is often scared of touching any legal document in case they open up a company to risks that they wouldn't have even recognized were there. And lawyers might feel precious about the documents because they've created them, or this document has been through an immense amount of governance before it was approved, and now they don't want to go through the same process again, or they're concerned that if they do open it up to the content writers, that they will introduce risk. So they share the same concerns as content writers. And I think if you have a standard that says, actually, it's okay, and not only is it okay, it's desirable because what you're doing has benefits, that's where the change will occur. Because one of the barriers that I've seen to the whole concept of design thinking in legal products, including contracts, is that no one really talks about the business case for it. Have you got any examples of where good business outcomes occurred because of the redesigning of contracts?
Absolutely. I mean, there's actually a whole there's a book that Joe Kimball wrote. You can look it up, called Writing. I've got it next to me. I'm reading the title. That's what I'm looking for. Writing for Dollars, Writing to Please. And he actually collates a lot of these case studies about how, he's a lawyer, but he recognized many, many years ago that it's not just the stick, it's the carrot, right? We have to show the business value. And he's collated the business value there. What I like to talk about, and we often aren't good at measuring these terms and conditions, the value to the business, and often the findings are a little bit confidential, and that's why I can refer to like published case studies. But what you find when you've done the terms and conditions, there's a couple of business benefits. Firstly, what I do want to say first is around risk, and this is something I'm going to say that's a little bit contentious, but as someone who's rewritten a lot of contracts, very often I will read something and I'll go, are you really saying that? I can't understand that. And I will ask the question to the legal team, what are you actually meaning? And they'll go, oh gosh, that was a mistake. That crept in kind of, 2011. And actually it was a mistake. I've worked on contracts where the plain language process, just the process of that very deep analysis, has picked up quite serious issues. So firstly, that's kind of a misnomer, thinking contracts are always perfect as they are. And I've worked on enough to know they're not. This is why your work in standardization is so important. But because often they're not perfect. So we're starting from an imperfect place very often. I think more often than we'd often like to kind of admit. In terms of the brand benefits of it, I've worked on a lot of measurements where we look at customer satisfaction scores before and after reading, impressions of the brand before and after reading. Gartner's got a very classic study where they showed the more you understand, the more you trust. And they proved this relationship between comprehension, understanding, and trust. Because gone are the days where you go like, yeah, I can't really understand all this fancy stuff about the legal contract, but I trust my bank. That's gone a long time ago. And so we do know there is a lot of research that shows comprehension, trust go hand in hand. And at the moment, organizations are measuring that comprehension and measuring that trust. And that's where the findings are kind of obvious in those organizations with those measurements. I do wish that there was a doctoral student out there that would publish a good modern collation of that type of study. I don't know of any published studies that were sitting within organizations.
Mm, mm. That's great, great examples. And how do you think generative AI is going to contribute to this movement?
It's an interesting thing because I do know you probably a lot like lawyers, content people, a lot of them are inherently a bit nervous, a bit saying but mildly, but nervous, concerned about the risks of generative AI. Because we all know that the time and effort and rigor it takes to write a contract. And we all very kind of our intuition, I think, is very worried about it. However, I always say if you do, I think generative AI is just like any other aspect of content or research, that if you do it badly, it's going to have a lot of risk and be bad. But if you do it well, it can actually help scale our efforts really effectively. And I'm very interested in that because I think if you look at what I started to talk about at the beginning of readers, I think people are very concerned that somebody will try and just run their contract through, ChatGPT or Claude or whatever model they're using and it'll do the plain language, and that will be very risky. But we still want to follow the standards. So if we look at what generative AI can do to help us understand our audience, there's a lot. AI can do
Yes.
wonderful things in terms of analyzing reader input through all of its tools. A not very obvious example is creating, and I've done it, creating little GPTs on personas and asking the persona if they understand or not. It's not perfect, but it's a great way to kind of start feeling out the audience. I always say you've got to research the audience and sit in the room with them as well. But once you've done that, it can scale those efforts and make those efforts really achievable to a lot of organizations. So I think in terms of our knowledge of the readers, I think it's quite exciting what we can do. I think in terms of the actual rewriting of the document, I think generative AI can do some bits of it, but we've got to be very selective. It can't do all of it. And I think there's very clever generative AI linguists who are sifting through what it can do and what it can't, but it certainly can't do everything. And I think that's really kind of important to look at properly what it can do, what it can't do. What it can do, though, is once we've done that, it's quite good at flagging problems. So things like, flagging a Latin term, so it would be really great at that. So to me, the contribution of generative AI needs to be looked at in terms of a workflow going all the way through the standard. And there will be bits that it can do, and there will be human in the loop interventions at other bits, and there will again be bits it can do. There will be retrieval augmented generations, so RAG models, which will help us a lot with the rigor, where you put in your content and you tell the AI, only look at this content, you can't look at anything else. That can really help the rigor of what we're doing. So I think that generative AI will help us. Obviously, like everything, only if we do it right.
Yeah.
But if we do it right, I think it's really exciting. I think it'll make plain language perhaps more accessible and easier to scale in the long run.
I agree. I think generative AI will be key to the scale of this whole space because it has been quite inaccessible today. It's been a difficult thing to achieve, but now with the use of AI, I do think that we can just accelerate the way that we do this. So for legal and compliance teams that want to start adopting ISO, what's the best way for them to get started? What's the process?
Well, obviously they have to go to the British Standards Institute or the ISO and buy the standard. So they can't get around that. So I think getting the standard is the first thing. And then I think before they rush in and, try and do it, I think that it's very useful to have some kind of gap analysis between the way they're working now and the way they would work in the standard. And look at it not from an outpoint point of view, but from a process point of view initially. You do need to trust the process, as we always say with everything. But it is a good process. So you need to look at it from a kind of a principle point of view, from a process point of view, and then once you've done that, you'll identify the quick win gaps. And obviously, those are the ones you always go for, what's fast and easy. And you'll identify some gaps that seem a bit insurmountable at the moment, and maybe you'll have a longer term plan for those gaps. But I think you kind of need a roadmap to work towards complete implementation. You never start with everything. So always think of it. In a startup way, you think of your MVP, of plain language. So you think, what can I do quickly and easily in this process? Just remember, don't stop there. You've got to iterate to reach the standard. The standard is not going to be, I don't think, a one-off go to you, to any organization. It might be, there are some organizations that actually are pretty amazing at it already. So that would be great. But then I think to myself, there's so much change with generative AI that I don't think anyone will probably have got the standard plus the generative AI component done. So I think it's a matter of sort of starting at those quick and easy places, getting those wins, being able to show leadership those wins. So it's this whole idea of monitoring and evaluation as you're going, getting those outcomes as you're going, which often hasn't been done in the past. And it's one of the things that I really think organizations have to start doing is documenting those wins early on, so they can communicate those wins and move forward. So it's like any project. Start with the quick and easy bits, have a roadmap to the bigger bits.
Yeah. Awesome. Looking ahead, do you think plain English standard or plain language standards like ISO 24495 will eventually become mandatory? Because now they're not. Are we still in the early adopter phase of that?
Yeah, I think, with making it mandatory, I think, well, it will depend on the jurisdiction. I think that some countries are a lot more regulated in terms of plain language than others.
Yes.
So, you'll have some countries that already talk about plain language and have quite sophisticated definitions of plain language in their laws, never mind their regulations, and others don't. In terms of the UK, I think it's interesting at the moment because I think that the UK has always had, treating customers fairly, and the Equality Act, and various all the consumer regulations. It has had various regulations that have talked about clear communications, talked about plain language, but they haven't mandated any specific framework because I don't think there has been a specific framework they can mandate. So I think it's a great opportunity now for regulators to look very closely at this and say, well, is this something that we want to mandate? And I think the regulators will have to decide. I can say my personal view, is I think it's almost crazy not to, because we've got something that, just through the process we know is okay. It's not overly prescriptive. It doesn't say this is the word you will use, which we all know is the wrong way to go. So it is about a process. It is about a principle. And I think that's a really useful thing for a regulator, but that's my opinion. So I think the regulators will have to look at it and think deeply about it. If I were an organization, I would mandate it within my organization to have a roadmap to meet it, simply because I think it takes all the doubt out and the lack of certainty out of what we are trying to do with this. So we'll have to see what comes of it in the longer term.
I do see a world where opaque, overly legalistic language is completely frowned upon and perceived as a strange thing for a company to do. I remember a few years ago where someone printed out Instagram's terms and conditions, and it was just just reams and reams and reams of it. And then I went to a modern art museum, and they had it printed on the wall,
Yeah.
and I loved it. Yeah. So I think stuff like that will change the culture and has changed the culture, but it will get to a point where regulators are seeing that the expectations, particularly of consumers or smaller businesses, are just not met by the larger organizations, then there is an imbalance of power that's created when you use your clever lawyers to create content that's just simply not consumable. So I think we're already seeing hints of it being moving towards it being obligatory, but yeah, it's not yet. But I do think it will. So may as well start
You
thinking
may
about.
as well start with the standard. I think that you're absolutely right. The interest in design thinking, in legal design, in deceptive patterns, where there's a lot of work being done there. To me, it's all part, and the plain language. It's kind of all part and parcel of this same issue that consumers are really skeptical now. They
Yeah,
want to be told what they need to know and what they want to know. Trust is earned; it's not just given by people. And so I do think that we will. The time is the time is nigh. The time is coming for stopping these practices like we've updated our terms and conditions. That when I stop seeing those with just a link to the new terms with no indication of what's changed or why, then I'll know it's changed. I think we've got a way to go, but I agree with you that we are entering that phase.
yeah. Francis, have you got any last tips for anyone who's looking to move into a better world of contracting? How could you help them if they needed your support?
Well, the way that I work with organizations is I start with looking at a key document or a key piece of content that they have. And I do an analysis of that, and I've got some cool tools to do that. And then I make sure that I speak to a few users of that document. And I create both a textual analysis of that document, which is now very quick with AI, which is cool. And then I create a real human interaction analysis of how people are understanding what their baseline knowledge is from that. And out of those two analyses, we come up with a plan to bridge them, to get the person, the real human at the end, to be able to understand this document. And we work to how organizations can cope. I don't believe everything is perfect at the first go, and I don't push people to do that. But I always show that what we do is part of what we'll do in the first phase. It's part of a much bigger picture of where we can get to. But my last piece of advice for anyone who wants to adopt these principles is go and speak to somebody, speak to a family member, a friend, someone who'll be honest with you about the document, not tell you that it's brilliant. Speak to somebody honest and get an honest opinion of what they understand and what they don't understand. And then go from there, go from that understanding. And don't just say, do you understand this? Say, look at this clause 3.5.2, read it and tell me exactly what it means.
Yeah.
And go from there. So that's my last advice. Speak to your users just before you make any decisions.
Love that. Francis, thank you so much. I've really loved our conversation, and it was so informative. So thank you so much for giving us your time today.
Thank you so much for inviting me.
Thank you. And for everyone who's listening, please tune in for the next episode of Future Contracts, where we'll be exploring more on the future of contracts. Thanks.